Hi, I'm Michelle. Welcome back to Finally Revealed. Today I want to talk about whether or not you need a contract. In order for you to determine whether you need a contract, there are various principles that you could follow. The first one being if you are going to need to enforce somebody's agreement, which is really what a contract is. It's just an agreement. There's legal elements that go into it, but I don't know. If you have an agreement, that's a contract. Whether or not it's a legally enforceable agreement that you can prove is going to be more difficult unless it is in writing. So you might want to think about that. I have another video on how to read a written contract, and in there I highlight the main reasons that you have a contract. So you might want to watch that, and if that makes you reconsider what you're doing and then you say, you know, I should have it in writing, then there you go. Go have somebody help you and put it into writing. But then there are certain situations where you can't enforce an agreement unless it is in writing. And that a law called the Statute of Frauds. And that was so that you could prove what the actual terms were. And these are significant situations where people can have significant rights lost, and so they must be in writing. So there are 5 main areas that are covered by the Statute of Frauds, and then decide. The first one is where there's somebody who's going to make a promise to cover for somebody else. And this would be indemnity, which there's a video that tells you. I have another video telling you what indemnity is. But if you're going to indemnify somebody, it has to be in writing. If you're going to pay somebody else's bill, for example, a guarantee, that has to be in writing. So whenever you're going to stand in the shoes of and you agree to take on an obligation that someone else has already taken on, it needs to be in writing. The next one is in connection with a sale or transfer of land. Contracts pertaining to land need to be in writing. The next one involves the time that you're going to have this agreement carried out. If by the terms of what you're agreeing to, what's going to happen is not going to happen within 12 months of when you agree that this is going to happen, then it needs to be in writing. And if you have any agreement pertaining to a marriage, meaning a prenuptial or postnuptial agreement, that has to be in writing. The next one is when you're going to charge your administrator or executor to carry something out after you die. In other words, if the agreement that you have is going to not be performed during your life, specifically it's going to be about something that's going to happen after you're gone, that needs to be in writing. And then the wild card one, which I still recommend this to my clients, and the lower threshold is $10,000. Some places it's $100,000. So you need to check where you are. But certain amounts of money, a contract over a certain amount of money needs to be in writing. Now, these are where the Statute of Frauds covers what needs to be in writing. Whether it should be in writing, that's going to be your call, because the whole point of a contract is to bind people to the agreements and to enforce those agreements if they don't do what they've agreed to do. So the more specific you have something, the easier it's going to be to enforce it if that becomes necessary. Now, some people are going to do what they promise that they're going to do. We like those people, but not everybody, whether by choice or other circumstance. So make sure you understand these areas that must have something in writing, and then hopefully it'll give you some peace of mind. I hope this was helpful to you. If it was, let us know. And if you'd like to learn about our new videos, follow us on Twitter at FinelyRevealed, or like us on Facebook, or subscribe. I'll see you next time. Thanks for watching.